Live on YouTube. What the hell?
We'll have to mute your phone or I will mute you. All right, this is case number 2346533. This is Probate Property Management versus Sharita Truelove and occupants of property at 9524 Fielding Street. The court is also at this time calling 2347386. This is Carla Robinson versus Eliza Robbins and occupants of property at that property is located at 14600 Strathmore in the city of Detroit. Regarding 6533, your appearance for probate.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
All right, and thank you for defendant in this matter. It looks like Ms. Indra is representing defendant. Counselor, are you appearing?
Good morning, Your Honor. Andrea Enright for the defendant. Yes, Indra had been representing the client. I think she submitted a conditional dismissal to Ms. Hunter that should be entered this morning.
Right, and I do have that document, and that's consistent with what you believe should occur in this matter as well. Counsel, is that correct, sir?
That's correct, Your Honor.
All right. Do I have Ms. Truelove on this Zoom? Say something if you're there. All right, the court will sign now the order of consent order of conditional dismissal in this matter, and that will conclude this matter again on a conditional basis. My clerk will get that order out as soon as possible. In regard to, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
In regard to 7386, Carla Robinson versus Robbins, it looks like there is a proposed consent order in this matter. Counsel, your appearance for the plaintiff.
Good morning, Your Honor. Alan Dyer appearing on behalf of the plaintiff, P54857.
And Judge Steve Lockhart, P32090 for defendant Robbins.
Thank you, counsel. And counsel, it looks like everybody signed off on the consent order for conditional dismissal, and that's the way you wish the court to proceed. Is that correct, sir?
That's accurate.
Yes, please.
All right, thank you. I'm signing the order then at this time, and that will conclude the hearing on that particular matter. Okay. Right. Do I have Mr. Coleman in the Zoom, sir?
Judge Fred was here, but he must have gone to another courtroom.
Not a problem. All right. Let me call 20347457, and I'm also calling 20346340. In that particular matter, 6340, that's VEOT Investors LLC versus Carol Orr and occupants of property in the city of Detroit at 20050 Joanne. It appears that there is a consent in that matter. The court has referenced also 7457, it's Team LVR LLC, and your appearance for defendant in regard to both cases, sir. Mr. Lockhart, I believe that you're on these matters. You're muted, Mr. Lockhart.
I'm sorry, Judge. Steve Lockhart for both named files for defendants. Attorney Smith is present for plaintiff on the second matter.
Yeah, I just noticed that it was him instead of Mr. Coleman on this file. Your appearance, counsel. Sorry about that, sir.
Your Honor, it's Justin Smith, and I represent the plaintiff Viat on the case ending in numbers 340. I would also like to state for the record that I do have a client in the courtroom with us today as well by Ms. Lolita Allen, who's a management representative.
All right, and good morning to your client. Where are you?
I'm here, Your Honor.
All right. Good morning to you. Thank you for being here, Ms. Allen. Looks like
Thank you.
there's an agreement, Mr. Smith, in this matter. You signed off on it, and you wish the court to go forward accordingly. Is that correct, sir?
We did, Your Honor. I've had a very good conversation by chat with Brother Counsel, Mr. Lockhart, this morning, and also by email within the last couple days regarding a proposed change specifically to paragraph 5 of the last short form, which is the terms of conditional dismissal. Mr. Lockhart, I believe, had Madam Clerk attach a Post-it note with the proposed change that we're going to make. It's minor. Mr. Lockhart, you're still with us, correct? You can hear, correct?
Affirmative.
Okay, since you were the master of the
We stop you
language,
for
and I
just
was,
a moment, Mr. Smith. Your device, I'm guessing, let's turn this up a little bit more, because I'm not hearing you real well, Mr. Smith. So just one moment, sir. All right. Say something now, Mr. Smith.
Your Honor, testing the audio now.
Judge, this is Lockhart. I can hear him fine on my end.
Yeah, it was a little low, and I wanted to make sure the court reporter would be able to get the information as well. I'm ready now, Mr. Smith, and I know that you're referencing number 5, and may continue on that issue.
Okay,
Judge,
very
that's
good.
Mr. Dyer typing or something. Thank you, Mr. Dyer. You need to mute. Thank you.
I apologize. I thought I was on mute.
Not a problem. Thank you, Madam Court Reporter.
It's
All right,
rare,
you may
Your Honor.
continue.
It's rare, Your Honor, where typing can overcome my voice, but just ask my wife; she'll have a lot to say about that. Nonetheless, Attorney Lockhart and I have spoken, and by every point, just about, we have an agreement on this case. We were going to change some language on paragraph enumerated number 5 on the 3rd page of the submission, which is terms of conditional dismissal. There was a concern relative to deadlines relative to proposed repairs. Mr. Lockhart had in chat or by phone today recommended a change in language upon my urging. Mr. Lockhart, did you provide that?
Judge, may I?
Yes, you may.
If I could put you to work, Your Honor, paragraph 5 under terms, on the second sentence, which currently reads, plaintiff will inspect and complete any necessary repairs. Could Your Honor please cross out the word complete and insert the word commence?
Word complete has been crossed out, and commenced has been inserted in that spot. And does that comply with your requirements, Mr. Smith?
That's fine, Your Honor. I believe that covers the intent of all the understandings of the parties involved.
Did you want that additional language at the end, Mr. Smith?
I really liked it. It's just
Okay.
that my memory's failing, but
Judge, I have a little more work for you.
All right.
At the very end of that sentence, which currently reads, any necessary repairs by January 31, 2021, could you please turn the period into a comma and write the words of the statute? The repairs are to be by January 31st to a condition fit for use intended and in reasonable repair.
Repairs will be done to a condition fit
For use intended.
Excuse me.
Go ahead. Was there something else?
It should read to a condition fit for use intended and in reasonable repair.
So stipulated, Your Honor.
Other than perhaps my bloody poor penmanship, that language is inserted at this time. the court has signed the order. You receive a copy as soon as possible. Thank you, gentlemen.
I appreciate everyone. Thank you.
Thank you,
Mr. Smith. Thank you, Your Honor.
We are on the record in one of Mr. Coleman's matters that I call. That's the suffix 7457. I'm also calling at this time the suffix 7374. That's Midtown Living Detroit versus Morgan Volkowski, and occupants of property is 633 Prentice Street, number 27. Also, there is the suffix 6806. That's Open Door Property Management Incorporated versus Asia Boykins, and occupants of property at 14203 Rockdale. The court is calling the suffix 6822. That's Golden Key Estate versus Amelia Robinson and other occupants of property at 2707 Leisure. All right, and your appearance at this time, counsel.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of each of the plaintiffs that's been called.
All right, thank you, counsel. And Mr. Lockhart did, in fact, enter his appearance with respect to the matter of 74517 LBR and occupants on Stout Street. I believe that was one.
That is correct. Right. We have a proposed consent agreement in this matter. My power at my office just went out, but it came back on. So we're submitting that that order over to you. It's basically a termination of tenancy. Defendant has until January 28th to vacate the premises. Writ cannot be requested until after February the 1st. If in fact the defendant vacates the property, this case can be dismissed.
Or you faded out.
What did you? Yeah, that's we're having some kind of sound thing going on. You faded out at the end, Mr. Coleman, and just address that part again about when the writ might actually be requested, sir.
The writ cannot be requested until after February the 1st, and if defendant vacates, this case can be dismissed.
Mr. Lockhart, does that size it up in this matter?
It sizes us up beautifully, Your Honor. To be frank with the court, we have one of the occupants connected. We are intentionally keeping this case as against occupants so that a judgment does not appear against this person by name. She has indicated to me that when she vacates, she will contact me so that we can surrender possession and keys to Mr. Coleman's client. That is not going to be included in the dismissal, but I make that as a representation of good faith to Mr. Coleman and his client.
All right, sounds good. Who's the person that's on the Zoom that connected to this case? Say something, please.
Ms. Pye, you're on mute.
Yes, I'm here. I'm sorry, I was on mute.
All right, thank you, Ms. Pye. And you understand what happens next in regard to this matter. Is that correct, ma'am?
Yes, I do.
Okay. All right, very well. I will mark this as awaiting the order, and that would conclude the matter here. And to the extent that everything goes well, then the case would ultimately be dismissed. I do wish you well, Ms. Pye. Thank you, counsel.
Thank you. Thank you. I appreciate it.
Thank you, Your Honor.
All right, regarding the other three matters that Mr. Coleman has on the call at this time, you've heard the call. Any counsels that are representing any persons on either of those three files?
Morning again, Your Honor. Andrea Enright, P70981. For Amelia Robinson, the last three is 822. She should be on the call as well.
All right, and Ms. Enright, if you will, you can give me an update on the status of this matter at this time, please.
Certainly, Your Honor. We have a conditional dismissal that is ready to go. My client should be on the call so that she could attest to it. I'm just awaiting her signature. Mr. Coleman and his client have approved it. And if we can't do that, I can then submit it under the 7-day rule or get her signature. I don't think there's a reason to adjourn it just for that reason.
Very well. Mr. Coleman, that sounds about right to you, sir?
That is correct, Your Honor. We have, my client and myself authorized EDP and conditional dismissal. just waiting for it to be submitted to the court.
All right, very well. Do I have Miss Robinson on this Zoom, ma'am? If you're there, say something, please. Miss Robinson, if you're on mute, you can unmute and say something at this time. All right. Based upon the representations as set forth by counsel on this record, the court will set this matter up for awaiting order. And upon the receipt of the order, the matter will be dismissed conditionally.
Thank you.
Thank you, Your Honor.
All right, thank you, counsel. And in regard to the other two matters that Mr. Coleman, that's on Mr. Coleman's call at this time, any counsel representing Morgan Golkowski, any counsel for Asia Boykins? All right. Do I have Mr. Golkowski living at property on Prentice Street, number 27, on the Zoom? If you're here, say something, sir. Do I have Miss Asia Boykins on the Zoom, living on Rockdale? Say something if you're on the Zoom.
Yes, I'm here.
All right, thank you, Miss Boykins, and I'm coming to you in just a moment. As it relates to the Golkowski matter, it looks like this is the first hearing regarding this matter, counsel. So I'm going to go ahead, sir.
Your Honor, this would actually be the second hearing. The first hearing was on November the 4th. It was adjourned out to November 24th for a door knock. However, the court was closed as it was scheduled for today's date. So there's been roughly about 2 months with communications going out from the court, whether it was the adjournment for the 24th and the adjournment for today's date, as well as them being served. We're asking that a default judgment be entered at this time if the court would so allow.
All right, under the circumstances, I have reviewed the file now, and given that there was a previous date where the court was open, defendant did not appear. Notice has been sent out for the second hearing, defendant does not appear. The court will grant judgment by default on the terms and conditions as prayed by counsel and as pled in the complaint, and will sign the order upon presentment. The matter be marked as awaiting your order, counsel, and upon submission, the court will sign the same and get it back to you, sir.
Your Honor, we will submit that to Madam Clerk in the next few minutes.
All right, thank you, sir. Miss Boykins, have you had an opportunity, ma'am? I'm on the suffix 806. Have you had an opportunity to talk with a lawyer or someone that may be able to advise you regarding your rights in this matter and opportunities that you may have to resolve this matter? Have you had a chance to do that?
No, I actually was trying to figure out if it was any programs or some type of assistance due to the pandemic, but I'm not sure. I've been looking, but I can't find anything as of now.
Okay. Well, what I'm going to do is I'm going to give you an opportunity to speak with a lawyer who is familiar with what your rights may be in this matter, as well as with the programs that may be available for you to advance through this process and perhaps get some assistance. That sounds like it makes sense to you, ma'am?
Yes.
All right. All right. So who's available to talk with Ms. Boykins at this time, please? All right.
Is there someone here from Lakeshore Legal Aid?
Yeah, this is a
Since it's
Lakeshore day on the docket, Judge.
I see.
Good morning, Your
someone.
Honor. I'm available to speak to the defendant.
All right.
This is
And,
Rima Kakarli.
who am I talking to?
Rima Kakarli, legal assistant with Lakeshore.
All right. All right.
I can as well. I can as well, Your Honor.
All right. All right. So you and Rima are going to go and speak with her. That makes sense?
Yes, Your Honor.
All right. All right. So I'm going to send you, Ms. Boykins, to talk with attorneys on this matter. I'm going to put you in a breakout room. You'll get a notification on your device as to the breakout room that you're going to. Just click on the notification and it'll take you right in. In the interim, I'm going to go ahead now and set the next hearing date regarding this matter, ma'am. And I'm going to set that over for the 25th of January at 9 o'clock a.m. January 25th at 9 o'clock a.m. Between now and that date, of course, you'll speak today with your lawyers, but you'll be able to be in contact with them regarding your rights and regarding ways that this case might be resolved. You understand
Your
that?
Honor,
Okay.
Your Honor, if I may for a moment, I don't intend that we're going to be able to represent Ms. Boykins, as I think the court is aware. If we could adjourn her case to the middle of February, we'll actually know a little bit more about what's going on with the new EDP program. I doubt that we're going to know by the 25th of January what that looks like and what the requirements are going to be.
Your Honor, unfortunately, I can't really, this has been going on for quite some time, a substantial amount old. I can't agree to a mid-February type of date. Maybe the first week of February would give some opportunity, but going past the first week, I think would be a disservice to my client.
All right, I'll adjourn it for a status on the possibility of EDP. And I know that Ms. Boykins, some of what we're talking about, you may not be totally familiar with. The lawyers are going to talk to you and help you to understand some of these things. So I'm going to go ahead and set that date for the first week of February, and I'll review it at that time and see what the progress is. Ms. Enright, what date works best? What day works best for you?
Your Honor, I am not committing to represent Ms. Boykins. I'm just knowing that this is a program that we had been discussing with the court, with our offices, to try to make sure that people get some legal advice in enough time to be able to work through whatever processes might exist for the future.
All right, understood. So what I'm going to do is I'll set this for the 1st of February at 9 o'clock a.m. February 1st, 9 o'clock a.m. That'll be the next date that Ms. Boykins will have to Zoom back in on February 1st at 9 o'clock a.m. At this time, I'm going to give you the notification, Ms. Boykins, to go to a breakout room where you'll be able to speak with a lawyer. You understand, ma'am?
Okay, thank you.
Your Honor, real quick, Andrea, do you want me to send you the ledger and the EDP documents just in case, or no?
I do not, Fred. Thank you, though.
Okay.
All right, and that's going to be breakout room number 1. Ms. Enright, I'm sending you there now as well. And also, where did she go? Ms. Reams.
Your Honor, I believe that completes my docket this morning. I'm going to forward those documentations to Madam Clerk. You and your staff have a wonderful day and a better weekend.
You too,
Likewise
Fred.
to you, sir. Good day.
Thank you, Jess.
All right.
All right, this is case number 2347560. This is Detroit, Michigan LLC versus Keith Shanklin and other occupants of property located at 15880 Billboard in Detroit. Your appearance at this time, counsel.
Yes, William Simon appearing on behalf of the plaintiff, P number 80352. Morning, Your Honor.
Good morning to you, sir. It appears that you've submitted, well, did I sign an order for, tell me the status on this matter, if you will, sir.
Yes, Your Honor.
Let me see. Is there a counsel on the other side of this?
Well, Your Honor, this is Marilyn Mullane from Michigan Legal Services, P30998. We just became aware of this case. We are also counsel in a federal class action suit challenging the plaintiff as defendant in that case on behalf of a class of purchasers, land contract purchasers. I have not had an opportunity. I do not have contact information other than an address here for this defendant, but I would like the opportunity, if matter could be adjourned, to and with contact information provided by plaintiff, to be able to talk to this defendant and represent him It's critically important, I think, in cases where there's a forfeiture action and there's much more at stake, obviously, in terms of the loss of housing and housing equity. So we need, and there's no EDP program for these cases, so it's all the more important that they be represented. And so I'm prepared to do that, but I would have to meet with Mr. Shanklin and know that he would want to be represented. And so I'm asking that the matter be adjourned. It looks like there was an adjournment to the 24th of November, which was, during the period that the court was closed. And then we had 3 holidays intervening between when a notice went out and this date. So I would like the matter to be adjourned perhaps to a date when Mr. Saman and we have several dates on these cases. I think there are about 50 of them scheduled between this week and February. And we're trying to assist in as many as we can.
Yes, Your Honor.
Excuse me 1 second, Mr. Saman. Madam Court Reporter, did you say something, ma'am? All right, you may continue, Mr. Saman.
Yes, Your Honor. I'm not sure that that's entirely correct. This defendant, Your Honor, I don't believe he's involved in that class action lawsuit that Ms. Mullane is referring to. I've spoken to this tenant numerous times. He doesn't even live in the property. I think he's in the business of purchasing properties and flipping and renting them out to other people. So it's not like he does not live in this property. He has several other cases with us as well. I believe we have personal service on this case. The proofs, I believe, were sent to your clerk. We talked.
Looks like I received an order for alternate service. That's what I see.
Correct. The order, yes. And Your Honor, the order was completed, and I believe I sent the proofs to your clerk. And I had spoken to the defendant before, Your Honor, on the phone. Last time I spoke with him, we were talking about entering into a judgment, and actually he was in the hospital at the time. So I'm not sure if he's still in the hospital or not, but it might be the reason why he has not appeared today, because I believe he was aware of the court date. So a short adjournment might be in order, Your Honor, to just figure out what's going on with that, and at least allow Ms. Mullane to speak with him. But
right, and if I can get the contact information, I will certainly pursue that. And if the facts are as you indicate, then that's a different situation with respect. Correct. We're representing occupants, but I need to know that.
All right, I do see that notation regarding the defendant being in hospital as of the 6th of November. So I don't know what's going on there. All right, yeah. So I'll go ahead and grant an adjournment in this matter to give Madam Counsel an opportunity to investigate and also just to find out what's going on in this matter. So maybe 2 weeks out, I'm thinking that's a crowded week, but the 25th would actually work better. I was thinking the 22nd, but let's move it to the 25th of January.
Yeah, that's good too.
All right, at 9:30 a.m. And the only information, Madam Counsel, I have in the file is I have address information on Mr. Shanklin.
I have contact information I can give to her. Yeah.
All right, Mr. Saman is going to share information with you. All right, so see you at the next hearing. I wish you all.
It occurs to me you might want to call out defendant name to see if they're connected. This is your officiant or meddler.
Thank you, sir. And what was the name on that again?
His name is Mr. Shanklin, Keith Shanklin.
Keith Shanklin. Mr. Shanklin, if you're on the Zoom anywhere, please say something. All right, very well. No response in that regard. All right, this is case number 20-347434. This is Hemlock Himmeloch, Apartments versus Nancy Snowden and other occupants of property located at 1545 Woodward Avenue, number 210. The matter is before the court on the filing of a complaint for non-payment of rent. The matter was heard on the 5th of November, adjourned to the 24th. At that time, the court was in fact closed. Your appearance on this matter, please.
This is Emily Sullivan, P81376, appearing on behalf of plaintiff.
All right, thank you, Ms. Sullivan. Do I have on this Zoom the defendant in this matter? Do I have Nancy Snowden?
Yes, I am here.
All right, thank you, Ms. Snowden. And Ms. Snowden, you live at the property on Woodward Avenue, number 210. Is that correct?
Yes.
All right, ma'am. Have you had an opportunity to speak with a lawyer regarding your rights in this matter and regarding whether or not there may be opportunities for you to get this matter resolved, Ms. Snowden?
Yes, I did briefly, but we kind of just got cut off and they didn't call me back. And when I in this morning, someone said I need to talk to Nancy Snowden, and someone there said we have to wait until Judge Coleman comes in before you can talk to her. So I don't know if she's still in the court or not, but it's just been very about my representation as in concern of counsel. But I talked to the management and
I'm sorry, say that again. You talked to?
Sure. Yeah, the Lakeshore was representing me.
All right, so hold on just a moment, ma'am. Let me see if I can get someone that will talk with you at this time. Who's available to talk with Ms. Snowden, please?
Good morning, Your Honor. Angela Malvig, P83921 with Lakeshore Legal Aid. I am available to talk to Ms. Snowden.
All right, thank you, Ms. Mulvey. Good morning to you. Ms. Snowden, I'm going to put you in a breakout room to talk with Ms. Mulvey regarding this matter and go over what your rights are and what opportunities there may be to resolve this matter. And Ms. Sullivan, I'm going to go ahead and set this up for a next action date. And that next action date looks like that's going to be the 25th of January. And I'll set that on at 9:30 a.m., January the 25th, 9:30 a.m. And that would be the date that you would Zoom back in, Ms. Sullivan. You understand? Sorry, Ms. Snowden. You understand, ma'am?
Yes, January 25th, 9:30, Zoom back in.
Yes, and right now I'm going to put you in breakout room number 2 with Ms. Mulvey to go over your rights regarding this matter. You understand?
Okay.
All right, so you'll receive a prompter on your device, and when you receive that prompter, just click on it. It'll put you in the breakout room. Ms. Mulvey will be there to assist you, ma'am.
So I can hang up from here, right?
No, you shouldn't hang up. Look on your device. You're getting a notification from me for room number 2. You should have it now.
Thank you, Your Honor. That concludes my docket for today.
All right, thank you, Ms. Sullivan, and good day to you, ma'am.
Thank you.
All right, this is case number 2034-5933. This is Shalonda Mosley versus Selena Martin and other occupants of property located in the district of Detroit at 19174 Algonac. For appearance for plaintiff regarding this matter. You may proceed for defendant. For defendant, ma'am, your appearance, and I'll come back to you, Ms. Mosley, in just a moment. For defendant, your appearance, ma'am.
Good morning, Your Honor. Jamesia Willingham with Michigan Legal Services, P83986, on behalf of Ms. Selena Mabins, and she is not connected to this call.
All right, thank you. Just one moment, Ms. Willingham. And I see Shalonda Mosley, you own the property on Algonac Street. Is that correct, ma'am?
Yes.
All right, and good morning to you. All right, Ms. Willingham.
Good morning.
All right, Ms. Willingham, tell me what's going on here, ma'am.
We submitted a judgment to the court, Your Honor. Ms. Mabins and family agreed to do a voluntary move and vacate and surrender possession on or before February 1st of 2021. If that is the case, then Ms. Mosley agrees to dismiss the matter. If not, she'll proceed with the writ.
All right. And Ms. Mosley, that makes sense to you that they're going to be out of there by the 1st of February or a writ would issue? Otherwise, the case would be dismissed. That's your understanding, ma'am?
Yeah.
All right. All right. So I don't have that written order in front of me just yet. It's going to be sent to me. When that order is sent to me, I'm going to sign off on it. And that will conclude the case unless the occupants have not moved. If they've not moved, then you'll be able to submit a document asking the court to, in fact, sign it. Understand? All right, you understand, Ms. Mosley?
Can you say that one more time?
No, of course I can. So here's what's gonna happen, Ms. Mosley. I'm gonna sign an order. That order is gonna say that the tenants have until the 1st of February to move. If they've not moved by that date, then a writ will issue. That means there is a written document that I will sign allowing a bailiff to remove them from the property if they've not moved by the 1st. If they move by the 1st, the case will be dismissed and this will be all.
Okay.
All right. I wish you well, the hearing on this matter. And Ms. Willingham, are you submitting the order? Are you?
That's correct, Judge.
All right. All right. I'll await your order. Thank you. And you can zoom out, Ms. Mosley, and you'll get a copy of the order once it's signed.
Okay. Thank you so much. And you guys have a nice, blessed day.
You as well. All the best.
Thank you.
This is case number 2346790. This is MIKA Properties LLC versus Pacheco and Jaquita Matthews and other occupants of property located in the city of Detroit. That location is 9386 Pinehurst. It appears the parties reached an agreement regarding this matter and signed accordingly. Your appearance for defendant at this time, counsel.
Judge, please the court, Steve Lockhart, P32090 for defendant Matthews, who are connected. We did file the proposed conditional dismissal that Mr. Abbott has approved.
All right. And I do see where Mr. Abbott is plaintiff's counsel in this matter. I see where he signed off. I also see Miss Jaquita Matthews. Is that you, ma'am?
Yes, Your Honor.
Good morning to you, ma'am. And you've been able to see the consent order of dismissal, and you're in agreement with the same. Is that correct, ma'am?
Yes.
All right. So I'm going to go ahead and sign that order, and that will conclude this case. And I wish you well, ma'am. All the best to you.
Thank you, Your Honor. Have a nice day.
Likewise to you.
Thank you, Mr. Lockhart.
Matthews, my pleasure.
Thank you.
All right, this is case number 2346802. That is RPM versus Pernell Freeman and other occupants of property at 16877 Cruz Street. The court also at this time calls the suffix 6778. That is Cordell Development versus Richard Mayberry and other occupants of property located at, just one moment, 2566 East Grand Boulevard, number 2, strike that number 323. The court is also calling this time the suffix 6786. That's Cordell versus Danielle Justice and other occupants of property located in the city of Detroit at 2101 West Lafayette, number 301. The court is calling the suffix 7366. That is Shack Property Management LLC versus Jasmine Robinson and other occupants of property located in the city of Detroit at 8234 Schaefer Highway. The court calls the suffix 7394. That's Bellcrest Apartments versus Tanya Clark and other occupants of property located at 5440 Cass Avenue, apartment number 1006. The court calls the suffix 4957, that is Tyson Kelly versus Jock Fulton and other occupants of property located in the city of Detroit at 18601 Greeley. The court calls the suffix, 6782, that is Bordell Development versus Cicely Cheeks and other occupants of property located in the city of Detroit at
Where'd you hear tonight?
Okay, at
I need to
2566.
go to the store. We need some tissue.
Located at 2566 East Grand Boulevard. The court calls the suffix 7398. That is Glencoe 1 LLC versus Andrea Davis, and other occupants of property located in the city of Detroit at 23851 Fullerton, apartment B17. The court also calls the suffix 1655, that's land contract Detroit versus James Green and other occupants of property located at 5051 Nottingham. Just one moment. All right, and your appearance at this time on various matters, Mr. Lockhart.
Judge, please the court, Lockhart P32090 for files ending 778, 786, and 957.
All right, looks like you also have it. Well, look like I'm counting four. I'm counting 802, 776, 786, and 957, right?
Yeah, I believe one of them that shows my name that Miss Willingham is handling.
All right, we'll address that momentarily as well. Ms. Willingham, your appearance regarding various matters, ma'am.
Good morning, Your Honor. Jamesia Willingham, P83986, appearing on matter ending 7366 for defendant Jasmine Robinson. She is not present on this call. On a matter ending in 7394, defendant Tanya Clark. She is also not present on this call. Matter ending in 7398, Andrea Davis. She is not present on this call. And then matter ending in 1655, Patricia Green, and she is not present on this call.
All right, in just one moment on your matters. And your appearance with respect to 6782, Ms. Indra. All right, do I have someone from Lakeshore, someone that's dealing with this this matter of Bordell versus Cicely Cheeks? I do see that there was a proposed order of dismissal, and it actually has Indra's name on it as counsel. Anybody know anything about that?
Good morning, Your Honor. Angela Malvig, P83921 with Lakeshore. I can confirm with Indra the case is ready to go and the matter is resolved. I believe she's in another courtroom right now.
All right, thank you, counsel. Do I have Cicely Cheeks on the Zoom? All right.
Judge, if I could interject, this is Lockhart.
You made it this time, sir.
Earlier this morning, both Mr. Abbott and his agent, Miss Mary Burke, were on the chat or the Zoom, and Miss Burke indicated that she had received payment in the Cheeks matter. I don't know if you're comfortable with that, but I think the matter's resolved.
Yeah, the documents that I've received would seem to validate what Ms. Movig has said and what you said as well. I'm going to go ahead and sign off on the documents at this time. This case will be conditionally dismissed under the terms as submitted. Thank you, councils, in that regard. Ms. Willingham, since you put the actual address to the property on each of the orders of consent, unlike Mr. Abbott, I'm going to let you go first. Excuse me, unlike Mr. Lockhart, I'm going to let you go first. And with regard to the suffixes 7398, 7366, 7394, in each of those matters, I do see proposed orders of orders of dismissals, where it is indicated that Mr. Abbott, on behalf of his client, and you on behalf of the respective clients in these matters, have gone over these matters and signed off on agreements that have been reached that result in conditional dismissals in each matter on the terms as set forth in the written documents. Is that the size of these matters, ma'am?
That's correct, Your Honor.
All right, I will grant the proposed orders at this time. I am signing off on each document now, and you'll receive copies of those documents momentarily. Thank you, Counsel, on these matters. And Counsel, with regard to the remaining matter that you have, I do not see a order in that matter. Update me as it relates to the suffix 1655.
Your Honor, with that matter in particular, I've actually lost contact with my client. After repeated attempts to contact her, she has not reached out, and I have no explanation for her absence. So at this point, I would actually defer to Mr. Abbott.
All right, very well. So I will, I'm going to recall that matter when Mr. Abbott is in Zoom so that we can address what should be done in that regard.
What case number is that, Judge? Sorry.
That case number is 19-361-655.
Okay, thank you.
Thank you. Just one moment, Mr. Abbott. I mean, excuse me, Mr. Lockhart. And Mr. Lockhart, in relationship to the matters that have been called, it appears that in regard to the suffix 6802 and 6778 and 6768 and 4957, that in each of those matters there are proposed orders of consent dismissals on various conditions as set forth in the written documents in each of those matters. And Mr. Abbott, the plaintiff's counsel in each matter, has signed off on these documents. And it appears that you are prepared to go forward regarding these matters. Is that correct, sir?
Judge, I'm sorry. It appears you're calling out case numbers that might not be mine.
Yeah, one is not
enough to follow you.
Yeah, well, looks like 6802 is not yours. I'll address myself to that matter.
Okay.
I was referring, I made a mistake there. This is, I have three involving you: 6778, 6786, 4957.
Yes, Judge, that is correct. Mr. Abbott and myself have executed proposed conditional dismissals with terms. We'd ask Your Honor to approve them. I did need to note to you, sir, that on file ending 957, pursuant to the terms, there is a representation that named defendant Arnold has vacated, and the judgment is in the name is adding defendant Fulton. We'd ask that to be, put your clerk to work and ask Miss Hunter to change the case caption, naming defendant Fulton and all occupants, removing Arnold.
All right. The document, I made the adjustment with regard to Jock Fulton and all occupants. There is no reference in these documents to Arnold. And so I think
in paragraph 5 of the terms.
Yes, sir.
Pardon me, paragraph 4 of terms. Parties stipulate to amend defendant from Brendan Arnold to Jacques Fulton based upon Fulton's representation that Arnold no longer occupies the premises.
All right, I do see that. I do see that language, sir. And although the printout does not have the numbers, the paragraph numbers, I do see that particular language. I'm signing order at this time. And do I have Mr. Fulton on this Zoom somewhere?
Negative, and that's a female. I forget how to pronounce her first name. Jaquez or Jackie or something.
Jackie.
Jackie, there you go.
Yeah. All right, we got through it together. All right, that will conclude the court's hearing with respect to these three matters. I have signed off, or I'm in the process of signing with regard to each matter at this time.
Hello?
Yeah, just hold tight, man. We'll be with you in a moment. All right. The suffix 6802, that's Arc Properties versus Harnell Freeman. I note that this was previously Esther Harris's case. I know that she's no longer.
I can't hear you, honey. I can't hear you. You sound like you way down south. So.
All right. So who's appearing regarding that matter?
Good morning, Your Honor. Angela Mulvig, P83921 with Lakeshore Legal Aid on behalf of defendant.
All right. And I do see, looks like I have Ms. Freeman on this Zoom, do I?
Morning, Your Honor.
Good morning to you, ma'am. It looks like an agreement has been reached in this matter, Ms. Mulvig and Ms. Freeman, and that agreement would provide for a conditional dismissal. And there are some EDP funds that have been made available. And my understanding is that the parties have signed off and wish to proceed in this manner. Is that correct, Ms. Freeman?
Yes, Your Honor.
Thank you, ma'am. Ms. Mulvig, is this the way that the parties wish to proceed? Your understanding, ma'am?
Yes, Your Honor.
All right, so I am going to go ahead and sign the proposed consent at this time. And that will conclude the hearing regarding this matter. This case is dismissed conditionally as set forth in the terms of the written document. I wish you well, Ms. Freeman. Good day to you, ma'am.
Thank you, Your Honor. Everyone have a great weekend.
You too. Thank you, Counselor.
Thanks, Your Honor.
Bye.
All right, this is case number 19-369941. This is Kim Green versus last name is Steels, Sunita Steels, it appears. The matter is before the court for review on today's date. It looks like there is a proposed consent for a dismissal, conditional dismissal in this matter. Your appearance at this time? Do I have
Mr. Green, do you want to identify yourself?
Do I have Ken Green?
Judge, please the court, Steve Lockhart, P32090, standing in for defense attorney of record Valerie Dahlstrom.
Thank you.
Judge, Ms. Dahlstrom emailed a proposed conditional dismissal to the court this morning. I may be mistaken, but I thought Mr. Green did sign in. I don't know, maybe I'm mistaken, but we'd ask you to consider entering the conditional dismissal.
All right. I do see that document. It appears to be signed by Mr. Green, as well as Ms. Dahlstrom and Ms. Stills. Do I have Ms. Stills on this Zoom at all? All right. I'm going to go ahead and sign off on the order. It appears to be in proper form, and the substance appears to be consistent with the EDP program. So I'm signing the order at this time, and that will conclude the hearing regarding this matter. Thank you, Counselor. All right, this is case number 2342258. This is Earth, that's URTH and Company LLC versus Eric Hovig and other occupants of property located at 9222 Longworth Street in the city of Detroit. Your appearance at this time, Counsel.
Good morning, Your Honor. Lucia DeSico, P72856 on behalf of plaintiff.
All right, thank you, Counsel. Good morning to you. And do I have Mr. Hovig on this Zoom, please? Say something.
My name is Eric Horvath.
Thank you, Mr. Horvath. Where do you get the hard sound at the end? And which ethnicity is that?
Hungarian. We have there's right? Yes, that's right. I'm Hungarian. Yeah. There's 4 A's in the Hungarian alphabet. We have the same alphabet as Americans, but there's 4 A's depending on punctuation of the A. And the enunciation of that vowel, that particular vowel, determines what you say.
All right. That's why it sounds so strong at the end. Thank you, sir. All right, Ms. DeSico, update me regarding this matter, ma'am.
Yes, Your Honor. This is a hearing for a writ, Your Honor. The writ was actually submitted to the court in October. Our first hearing was in November, and it was adjourned. And now we're here again, just requesting the entry of the writ.
And I do see, I do have in the file your application for writ regarding this matter. All right. So, Mr. And you know I'm going to mess it up, but Mr. Havan, did I get it halfway right that time, sir?
Correct.
All right. You understand the proceedings of?
I'm sorry.
Because your device is breaking up some. I said you understand the proceedings that are before this time.
Okay. No, I don't. But I think the court needs to get some background information as to this case.
Well, let me do this.
Her client.
Well, let me do this. Let me ask you this.
Pardon me?
Yeah, let me do this. Have you had an opportunity to speak with a lawyer regarding your rights in this matter, sir?
No, not really.
All right, well,
but her client broke into my house while I was living there.
Yeah, let me stop you.
Let
me stop you before you get into the issues, because there's some procedural things. Let me see if I can get you linked to someone that might be able to assist you with your legal rights and the issues that may be pertinent to this particular case. So let me see if I can get a lawyer that you can go over what those rights are and that can present this matter to me.
But I want this on record that her client broke into my
Let me
house.
stop you. Let me stop you, Mr. Hovak. Mr. Hovak, I know what you want. There's a procedure for doing it a certain way, and that's why I'm stopping at this point. So let me get you to talk to someone, and then they'll give you the right format to be able to present what you want to present to me. So
Okay,
who's available to talk? Excuse me, just one moment, sir. Who's available to talk to this gentleman and come back into the Zoom? I need someone out there that can speak to the Zoom.
I guess nobody loves me.
Good morning, Your Honor. I'm with Lakeshore, Rima Kakarli. I can begin the intake.
All right. So I'm going to have you to talk with Miss Rima Kakari and go over whatever the issues are, and then I'll allow you to come back into the Zoom, and we'll see where we are at that moment. You understand, sir?
Okay, well, the obvious question here, the white elephant that's in the room is, how do I talk to her? I'm not a computer guy, so how are we going to communicate?
All right, here's what's going to happen is I'm going to send you a link to a breakout room, a private place where you can talk with your lawyer. That notification.
I beg your pardon, Your Honor, and please have mercy on my immortal soul. I don't even know what that means.
All right. So you're on that's not a problem, sir. You're on a computer device. On that device, you're going to see a notification come up, because I'm going to click a notification for you to go to a certain breakout room. That's going to be breakout room number 4. So you should get the notification right now. You see it?
Join breakout room, WC.
Yes.
Okay. So
That's
I
what
hit
you want to
join?
do. Yep, just hit join, and then I'm sending someone there to talk with you. Just hit join.
And how do I get back?
Oh, somebody there will tell you what you need to do to get back, okay?
Okie dokie.
All right, sir. All the best.
Thank you.
Your Honor, could you send me to that breakout room as well? This is Angela Malvig.
Yes, Ms. Mulvey, I'll be glad to send you there. So let me get you out of, you've been somewhere, so let me get you out of there, taking you out of 4 and sending you to, taking you out of 2 and sending you to 4. And Ms. Kakari, I'm taking you out of 1 and sending you to 4 as well.
Thank you so much, Your Honor.
Thank you.
Thank you. And Ms. DeSico, we'll come right back to your matter in just a moment, ma'am. Thank you for your patience this morning. I know it's been a bit.
No problem, Your Honor.
And Judge, could I have that case number again? Because I don't see it on the docket.
Thank you, ma'am. That's 20342258.
Okay.
All right.
Thanks.
And Mr. Dyer, are you there somewhere, sir? This is case number, Mr. Dyer.
I am here, Judge.
Case number 2347445. This is Carla Robinson versus Jessica Ludeman and other occupants of property at 10960 Balford, unit number 10. The court is also calling 2347449. That's International Property Fund. International Property Fund LLC versus Shanita Grant and other occupants of property at 16535 Ardmore. All right, and your appearance at this time, counsel.
Good morning once again, Your Honor. Alan Dyer appearing on behalf of the plaintiff, P54857.
All right, and your appearance regarding the suffix 7449 for Shanita Grant.
Alan Dyer
Good
appearing
morning.
on behalf of the plaintiff.
I got you,
Sorry.
Mr. Dyer.
Okay, sorry about that.
Thank you, sir.
Good morning, Judge Jamesia Willingham, Michigan Legal Services, PA3986, appearing on behalf of Ms. Shanita Grant, file ending in 7449. And just for clarity, Judge, did you call 203-47445?
Yes.
Okay, so also Jamesia Willingham appearing on behalf of Ms. Jessica Ludeman.
All right, very well. Thank you, counsel. So let's deal with the 7449. It looks like there is a signed proposed consent order of conditional dismissal, and Mr. Mr. Dyer, you signed off on that and wish to proceed in that manner. Is that correct, sir?
That is correct, Your Honor.
Ms. Willingham, on behalf of your client, you signed that matter on this matter as well and wish to proceed accordingly. Is that correct?
That's correct, Judge.
Do I have Ms. Grant on this Zoom? If you're here, ma'am, say something. All right, I am signing the order at this time, and that will conclude this case, and the parties will receive copies momentarily.
Thank you, Judge.
All right, Ms. Willingham, update me regarding the other matter, suffix 7445.
Your Honor, regarding that matter, I sent a conditional dismissal to Tammy a few weeks back. I will resubmit to the court.
All right, and that makes sense to you, Mr. Dyer, regarding this matter?
Yes, Judge.
All right, the court will sign the order upon presentment, and with apologies, we've had a little bit of a transition, so Ms. Willingham, if you get that out. We'll take care of
Understood.
it. This is case number. All right, this is case number 20, 347453. Becker Leasing LLC versus Leslie Inslee and other occupants of property at 7170 Nevada. Your appearance at this time, counsel.
Yes, good morning, Your Honor. William Simon appearing on behalf of the plaintiff, number 80352.
All right, thank you, counsel. For defendant.
Charlene Snow from Michigan, from United Community Housing Coalition, P26923, on behalf of defendant Ms. Inslee. And Your Honor, I believe that
Madam Counsel, Ms. Snow, I can hardly hear you.
Yeah. Can you turn up your volume?
I think it's up. I will try. Let me plug this in. Maybe it'll be better.
Is this any better, Your Honor?
Oh my God, yes.
Okay, I don't know what's going on with that volume. Charlene Snow from United Community Housing Coalition, P26923, on behalf of defendant Leslie Inslee. And Your Honor, we have reached an agreement. I emailed to your court reporter and yourself yesterday evening a copy of our consent order for conditional dismissal and the addendum, which I believe, both of which I believe have been signed by all parties. And in fact, I think the check was cut for this matter yesterday. So the proverbial, the check is in the mail, applies here.
And I did receive the order. My clerk is printing it out as we speak, or momentarily, and I'll sign that order once it's in my hands, and we'll get it back to you. That
Thank
works.
you, Your Honor.
Mr. Saman, is that correct, sir?
It is, Your Honor.
All right. So it's all taken care of. I'll sign the order as soon as we get it printed out. I remember receiving it last evening, and so we got to get it printed out. All right.
Thank you, Your Honor.
Very much.
Thank you, Your Honor.
That's it for me, Your Honor. Have a good one, and Happy New Year
All
to
right,
you.
good day to you, sir. This is case number 23-47473. This is Royal Real Estate versus Team Walker and other occupants of property 11691 Bramble. The court also calls the suffix 7477. That's Neighborhood Property Consultant versus Emmanuel Reeves and Marie Reeves and occupants of property located at 14831 Strathmore. The court is also calling the suffix 7481. That's NFH Realty LLC versus Michelle Shamley and other occupants of property located in the city of Detroit at 20113 Conley. The court calls the suffix 70 That's Eagle Homes, Eagle Home Management LLC versus Michael Smith regarding property at 16149 Monica. Your appearance, counsel, except regarding the last matter. The last matter is Mr. Applebaum case. So, counsel, your appearance on the first three.
Good morning once again, Your Honor. Alan Dyer, appearing on behalf of the plaintiffs for the first three matters called.
Thank you, counsel. And I believe that Ms. Willingham is on the subject 7481. Ms. Willingham, if you're there, your appearance regarding this matter, ma'am.
Good morning, Judge Jamesia Willingham, Michigan Legal Services, P83986, on the matter ending in 7481 on behalf of Ms. Michelle Shamley, and she is not on the Zoom call.
Yeah, I do see her there. Ms. Shamley,
No, I
how are
am
you?
here. Hi, I'm
Yeah,
here.
good morning to you, Ms. Shamley.
Good morning.
All right. And it looks like there is a proposed consent order of dismissal in this matter. Looks like the parties have gotten things worked out. Part of that consent order is a judgment document. Strike that. Is a consent agreement. Is that correct, Ms. Willingham?
That's correct, Judge.
All right, Ms. Shamley, that makes sense to you, ma'am?
Yes.
All right, and Mr. Dyer, you signed off on this matter, and you're ready to proceed in this regard as well. Is that correct, sir?
That is correct, Your Honor.
All right, so Ms. Shamley, I am signing the order at this time. That means that this case is conditionally dismissed at this time. And I understand that part of this order says that you're going to be surrendering the property by the 1st of February. Is that correct, ma'am?
Yes.
All right, so I do wish you well. The order has been signed, and all the best to you, Ms. Shamley. Thank you, counsels, in regard to this matter.
Thank you, Judge.
Thank you. Thank you, Judge.
All right, and do I have T.N. Walker or counsel for T.N. Walker on this Zoom regarding 7473?
Yes, Your Honor.
Yes,
Charlene Snow from United Community Housing Coalition, P26923.
Ms. Snow, I'm having a problem hearing you again.
Again? I don't know why.
And Ms. Walker, I do see that you're there. Good morning to you, Ms. Walker.
Good morning.
Your Honor, can you hear me now?
Yeah, not so well, but I can hear you. You had great volume a few moments ago with the headset.
Yeah,
I see you got it on.
I don't know what's going on. Oh, that might help. Is this better?
Not much.
Geez, it's all the way up to 100.
Well, let's try it. Madam Clerk, Madam Court Reporter, I know it's got to be tough for you there, right?
Yeah, it's kind of tough, buddy. I can make it out.
Okay, can you hear me any better now, Madam Court Reporter?
No.
Yeah, it's really low. I don't know what it is.
Yeah, it's really
Judge,
low.
this is Lockhart. I can hear Miss Snow and will repeat her phrases if you wish me to be an interpreter.
That's the last thing I want, but if that's what I have to have.
Well,
We love you, Mr. Lockhart.
without the headphones, is this any better?
No.
She just said without the headphones, is this any better?
No.
Yeah, we hear. So let's just quiet down now and go ahead, Madam Clerk, Madam Reporter. If you have a problem with anything, let us know and we'll try and repeat it. All right, go right ahead, Ms. Snow.
Okay, Your Honor, Ms. Walker is on the line and she may want to be part of this as well.
Yes.
We, at this point, I guess, would ask for a short adjournment. I know that the landlord has sent in their documents for the landlord has sent in their documents for the eviction diversion program, which ended on the 30th of December. I do not have Ms. Walker's documents, though she says she sent them to someone. And I have searched our computer files this morning. I don't know where they are. It may well be that someone's put them in a part of the computer I don't can't find. But I know, as Your Honor is aware, there will be more funds coming down the road. We expect in a couple of weeks. That should help people with their back rent. We're waiting for the federal government to release those funds. So I'm asking for a short adjournment. If we don't find her documents, we can get together with her and have her resubmit documents.
All right, Miss Walker, you were able to hear what your attorney has communicated to the court. Is that correct, ma'am?
Yes, that's correct. I can hear.
All right. So I think I'm going to go ahead and adjourn it and give an opportunity to try to repackage this based upon some new funds that are going to be made available in the near future. Mr. Dyer, let me get your input on this, sir.
That's fine, Judge. Ultimately, this is a termination case. However, I do understand that my client has expressed a willingness to participate in the EDP. And if in a couple of weeks we anticipate there being some additional funds available, I think it would be prudent to try to take that shot to try to salvage a relationship if we can. So I would request the court adjourn it. I guess, Charlene, how much time do you think you need?
I'm thinking that first February, based upon what I've been hearing about the funding, as a realistic time as to where everybody will at least be able to see how this is coming together.
I'm not going to object to that, Judge.
So what date of the week? And well, February 1st is on a Monday. So.
Your Honor, I'm generally in your court on Thursday mornings. I don't know where Mr. Dyer is on the 4th.
He's here.
Everywhere, always.
I'll set it on the 4th of February at 9:00 a.m. And we should see where we're going with that. Ms. Walker, that's the next date that you'll tune back in, ma'am. Your lawyer will be in touch with you, and they may need to regenerate paperwork because that seems to be a part of the concern here. But the next date to come back with the same numbers you came in previously will be February the 4th at 9:00 a.m. You understand, ma'am?
Yes, I do understand. Thank you.
Before you hang up, Miss Walker, may I verify your email? Is it just the first part? Is it TEANAWALKET as in Tom?
Yes, it is. That's correct.
Okay. And then I will try to email you, and you and I have to keep communicating so that we don't. Okay.
Okay.
All right, that concludes the hearing in this matter. I wish you well, ma'am, and let's hope that we can get this to a conclusion sometime soon. All the best to you, Ms. Walker.
Thank you.
All right, regarding the suffix 7477 neighborhood property versus Emmanuel Reeves, Marie Reeves. Do I have counsel? I do see Mr. Emmanuel Reeves on the Zoom. Do I have counsel for the Reeves in this matter?
Yes, Your Honor. Charlene Snow from United Community Housing Coalition, P26923, on behalf of Emmanuel Reeves and Marie Reeves, who I think may also be on the call by telephone.
Yes, I'm here.
All right, thank you. Thank you, Ms. Reeves, and good morning to you as well, ma'am. All right.
Good morning.
Now, Madam Counsel, you may proceed at this time, please.
Thank you, Your Honor. We are asking for the case to be dismissed. Both of the Reeves moved out of this property well before the case was even filed. I sent yesterday, I believe, or the day before, a copy of a lease that Ms. Reeves provided to me that she signed at another address on January 10, 2020. She moved out of this property at issue here in early 2020. So she's not been there. I've also provided counsel with copies of receipts she paid to the new landlord for that, pursuant to that new lease. And I believe Mr. Reeves also moved out of the property to another property. He can state when he moved out, but I think both of them were well gone before this case was filed.
Judge, if I may respond, we did in fact receive the email Ms. Snow referenced yesterday evening for the first time. So we were not able to get confirmation that the property indeed is vacant. However, there are 3 defendants here, the Reeves as well as occupant. We've got no objection to dismissing the Reeves out of this case based upon the information and the representations made here on the record. However, we would request entry of a default judgment against occupants only, just in case there's somebody still there. We shouldn't have to start all over again. I don't want to have to send a new 30-day and do all of that.
Your Honor, if I might ask the Reeves, so we're clear on the record where they are on that concept, I don't think we need to go into a side room for that. Mr. Reeves, have you got all of your belongings out of that property over on Strathmore?
Yes.
Okay, and you moved out some time ago?
Yes.
And Miss Marie Reeves, is all of your property out of that, all of your belongings out of that location on Strathmore? Is she on the phone?
She should be.
Miss Reeves, there she is.
There she is.
I'm sorry, my thing had went out. It's I didn't hear anything. It logged off.
Okay, my question to you, ma'am, is you moved out some time ago. Is all of your belongings out of that property on Strathmore?
It's just a couple of more things I have to get that's in the basement that I wasn't able to get when I moved out, but I can move them out most likely today.
Yes, I thought you were gone and everything was out.
No, I'm completely gone. I don't live there. I don't go there. It's just like a few more items from when my grandmother was living there that I haven't got a chance to get out at this time. But I can go today and go back and get the couple of items that's there.
Do you know who's living there?
No, if somebody's living there, I have no idea. I don't go to that property. I don't go over there. So I have no idea. I don't, like I said, I kept the keys with me. So if anybody moved in, that don't have anything to do with me at this point. I've been left since the end of December of last year.
End of December of 19 or 20, ma'am?
2019, sorry.
And why didn't you turn in the keys, if you could state that on the record?
We didn't turn into the keys because we don't have a landlord. And the landlord that we have, she's shiesty and she was stealing rent money. And I tried contacting her, her cell phone number she gave me, she don't answer it at all. I tried calling their actual office. It says that number is no longer in service. So we couldn't contact anyone. I haven't spoke to her since last year, and like, I think in last year in February, that was the last time I spoke to her.
Okay. So by tomorrow morning, whatever you have, what's the nature of what you've got in the basement?
It's my grandmother's belongings. She passed away.
Mr. Reeves was speaking. You said the items are your grandmother's belongings and she passed away. Is that what you said?
Yes, sir.
All right.
Well, I will grant the request for default judgment at this time. And Mr. Dye, you may submit a default judgment as to occupants only. The court will strike the names of Emmanuel Reeves and Marie Reeves regarding the property at Strathmore. The court being persuaded that they have vacated the property. Right.
Judge, all I would ask in addition to that would be that once they retrieve their final belongings out of the property, if they would simply do me the courtesy of just locking the building up and sending, if they can't communicate with their landlord, they could just send my law firm or to Charlene the keys. And
no, we don't want them in the mail.
Okay.
But
maybe they can drop them off or whatnot, either to you, Charlene, or to me, whichever one I would be fine with.
And I will send the Reeves by email your address on Coolidge Highway in Berkeley.
You got it. Perfect. Okay, we're all on the same page.
Yes.
All right, very well. And you can put that in the order. I'll sign off on it, sir.
Thank you.
All right. So ordered. That concludes the hearing on this matter. I wish you well, Mr. Reeves. I wish you well, Ms. Reeves. And
Okay.
Thank
Everybody
you,
have a good day.
Thank you, Your Honor. That concludes what I have before you as well.
all right, thank you. All right, I have Mr. Applebaum on the case of Eagle. I called it already, 7080. That's Eagle Homes versus Michael Smith. Your appearance for the plaintiff on this matter, if I have.
Good morning, Your Honor. David Applebaum for the plaintiff.
All right, thank you, Mr. Applebaum. For the defendant regarding this matter, please.
Good morning, Your Honor. This is Wendy Cooper on behalf of and with Mr. Smith and Ms. Bonner.
All right, thank you, Ms. Cooper. And I do see Michael Smith on this matter. And good morning to you, Mr. Smith.
Good morning.
Right, and who else you said was on, Ms. Cooper?
I believe Ms. Bonner is on. Perhaps not.
Ms. Bonner, are you here?
Yes, I'm here.
All right, thank you, Ms. Bonner. I see where you are now. All right. So what's going on here? Ms. Cooper, you want to update me if you will?
Sure. Your Honor, we are back on this matter because the plaintiff was contending that the CDC halt did not apply to this case. It is a termination of tenancy case, and we submitted a memorandum at your request.
All right. Yeah, and I'm just getting my hands on that doc. I do recall this case now. Mr. Applebaum?
Yes, Judge.
Have you had a chance to take a look at the memorandum, sir?
I did. It was emailed, I believe, yesterday. I did review it, and nothing has changed from my position. The CDC order does not apply to termination of tenancy cases. There are numerous exceptions listed in the CDC order, and the last exception says that any breaches of the lease other than non-payment of rents. This is not a non-payment of rent case. The lease expired in this particular case. A 30-day notice was sent to the defendants. They refused or otherwise failed to vacate. They are in breach of the 30-day notice. They are in breach of the month-to-month tenancy. So therefore, we brought forth this action. I would further note, and as I also indicated at the last hearing, if the court finds that the CDC order is ambiguous, well, then the court can look outside the four corners of the document and look at things like legislative intent. Obviously, there's no legislative intent here, but the frequently asked questions, which is on the website, clearly and unambiguously says that the CDC order does not apply to termination of tenancy cases. Just to reiterate, it says in the CDC frequently asked questions, what does the order do? And it says the order temporarily halts residential evictions of covered persons for non-payment of rent during September 4, 2020 through January 31, 2020. Further in the order, it says, it asks the questions, how can CDC help me from being evicted? The CDC document says CDC has issued this order to temporarily halt residential evictions of covered persons for non-payment of rents from September 4, 2020 through January 31, 2021. Therefore, this case, the CDC order does not apply to non-payment of rent cases, which makes sense because the intent of the CDC order was to help people who could not afford their rent due to COVID occurring. Basically, the defendants have resided at this house for numerous months due to the closures. They have not been paying rents. Of course, we didn't ask for money judgment. But having said that, they're living there, and they, for some inexplicable reason, think that they should live there for free. And the memorandum that was provided by Ms. Cooper does not change anything. It reiterates what I said previously, which is the CDC order does not apply to the termination of tenancy cases. For those reasons, we ask for a judgment in favor of plaintiff.
I understand the argument on the strict language of the CDC protocol. You would not, perhaps you would disagree with the notion that the objective of the CDC moratorium, if you will, was to prevent the movement of people under circumstances where there is a pandemic, and that specific intent, underlying driver of the CDC protocol, that intent would seem to provide a broader umbrella than the specific language contained within the CDC's order. Agree, disagree?
Disagree. The intent of the order is for unpaid rent. It's for helping people that were, laid off or fired due to COVID-19. That's why the order,
But of course, you would not disagree that the reason that the CDC is involved in this is because they're trying to prevent the spread of COVID-19, to keep individuals secure from possible contracting of that illness.
Sure. I mean, there's obviously a little overlap, and the CDC order, I mean, my personal opinion is a little poorly.
Well, I'm sure that would not just be an aside, and I didn't mean to cut you off. I don't think that the prevention of COVID and the protection of people from exposure to the same is an aside in the CDC's declaration. That seems to be a significant driver. The question becomes whether or not the CDC has so specifically set forth its order so as to undermine any implications of a more significant intent. That's the challenge in this school.
The Federal Register says specifically the statement of intent. There's a section carved out for it that states that it is to mitigate the spread of COVID. The document that he is relying so heavily on, the frequently asked questions, says in the very first sentence, this is a non-binding guidance. The CDC order carves out 5 narrow exceptions, and none of them apply to this case. And I don't think the plaintiff has contended that they apply in this case.
Under exception 5.
Well, you're saying that this is a possessory action, and the CDC order states that a landlord with a legal right to pursue an eviction or a possessory action is part of this case. So this is a possessory action by a termination of tenancy. Am I correct?
Well, I think that you're correct there, but the CDC's workup also says that its order applies to cases where there is a pursuit of rent and expression of an inability to pay. They hold one of the significant other drivers, because we talk about what is the bedrock of this and why do we have CDC involved. Obviously, they're trying to prevent the spread of COVID-19. That's the whole issue here. But then they also express an interest in addressing cases in which individuals have expressed some difficulty with payment in the context of non-payment cases. This, of course, is a termination action, and as such, I see that the Defendant's Counsel has pointed out to the court that the defendants are on all fours here as it relates to the underlying intent of the CDC, and that is to prevent the spread of COVID-19. And now, Counsel, on that issue of Mr. Applebaum, on the issue where the document says something about possessory interest in the CDC order, your response in that regard?
Judge, I think it's a red herring. It's because there are numerous exceptions listed in the order. Basically, Defendant's Counsel has a very broad reading, and in this case, no one would ever be able to be evicted under the CDC order because it's by its nature, an eviction is a possessory interest. So I don't know why that the possessory interest has any sort of probative value in the court's ruling. I would say, to be honest, even though not binding, this argument has been presented by a couple other judges, and Ms. Cooper's arguments have been rejected by a judge in Lapeer and by Judge Fonts in Warren District Court. I know it's not binding. I know the court has its own thinking. I get that, but the intent of, if you look at exception number 5, it says other than timely payment of rent. I mean, under exception 5, the intent is that you can terminate someone's tenancy for any reason other than unpaid rent. Under exception 5 of the CDC order,
That is correct.
we can apply. We can get the order of eviction. And for those reasons, under the exception. Sorry, go ahead.
I'm sorry.
Go ahead. I'm coming back to you, Ms. Cooper. Ms. Cooper, just a moment. I'm coming back to you. Go ahead and finish.
Sure.
Sure. So I was just going to, Judge, I would just focus on exception number 5. And it's very clear that it says violating any other contractual obligation of a tenant's lease other than the timely payment of rent. So we provided a 30-day notice. They did not vacate because once the lease expires, it's automatic month-to-month lease. Okay, so the lease provisions carry over. We provided a 30-day notice that they must vacate. They did not vacate. That's a breach of the lease. Whether it's the lease itself or it's the carryover lease, that's a breach. It's not for unpaid rent. For those reasons, under exception 5, the CDC order does not apply to termination of tenancy cases.
So, Your Honor, I have asked plaintiff for his filings with the court. He did provide them. I don't see a notice to quit in the filings. I didn't see one in the court filing. So I would ask, when was that provided?
Is that to me?
Yes.
Yeah, it sounds like I'm not getting, well, your volume is kind of off all of a sudden. Ms. Cooper.
Your Honor.
I wasn't hearing you as clearly this last round. You were saying that you didn't receive something from Mr. Applebaum, if you will.
So, Your Honor, I had asked Mr. Applebaum for his filings with the court. I do not see a notice to quit in the filings. I did not see one in the court filings. I'm asking when that was provided. I've asked my client. She says that she was not provided with a notice to quit or a demand for possession. I just would like to know when he filed this.
Sure. So, Judge, in the file, you'll see the complaint, and then the second page is the verification of compliance with CARES Act. The page following is the non-renewal of lease notice. That's the 30-day notice. It's not a scale form. So if the defendants are looking for a scale form, there's no scale form, nor is there one required. So the document called non-renewal of lease notice, that is the 30-day notice.
I believe the notice to quit is required.
That is the notice. That's a 30-day notice. It's just not the scale form, that's all.
All right, so, and Counselor, on the, you don't have to have the scale notice, but on the notice, I don't see anything where you provide proof of service regarding that notice. Or any verification with regard to when it was sent.
It does not state on the notice, but it's the on the top, February 13, on the top left-hand corner.
How mailed?
It's mail.
Well, it doesn't tell me anything about that. Notwithstanding, I do think that the plaintiff has perhaps we can address those other issues at another time. But it looks like there may be a sufficient basis given a notice of non-lease renewal, a sufficient basis to go forward with regard to to the non-lease renewal in this matter. As it relates to the CDC, obviously, one of the things that I think is quite clear about the CDC order is that it is aimed at dealing with the issue of whether or not persons are permitted to stay based upon having ability to pay or not. The ideal that if you don't have the ability to pay in the midst of this COVID environment, that under certain conditions and the signing of a certain affidavit, that you should not be able, or the plaintiff should not be able to move you out of your place of occupancy. That's clearly where the CDC order is going. If the court looks at it, I think that a part of this is that the court has to look at the sort of legislative or administrative intent that is associated with the issuance of the order. And that certainly is to prevent the eviction, termination, removal of people from dwelling places, dwelling houses, if you will, in the midst of COVID. And so it's almost as if the intent of the CDC clashes at a certain point in regard to these kind of matters. I could not, under any circumstances, I think, find that there is a blanket rule that says that you cannot evict anyone during the CDC order period. But I also don't think that I could simply reach a conclusion that the form of the action brought before the court vitiates any effort by the occupants to prevent and avoid being exposed to COVID-19 by sustaining a house of occupancy over the CDC period. That is a narrow issue and concern raised in the context of this case. And where we are now at the 8th of December, and the order is designed to expire on the 31st. We are at the 8th of January, I should say, and the order is designed to expire on the 31st of January. It almost makes sense that that the court would allow for a stay through that period of time. And so I'm troubled by those two dynamics. Let me ask a question here. So what's happening in this case? I mean, you know, there's not a judgment in this matter, and there is no likelihood that any judgment would be entered and eviction would apply in time to have the parties removed from the property by the 31st of January. I guess I don't see the purpose here. I don't really want to just issue a flat out determination under the CDC declaration, the CDC's protocol. But to say that the tenants cannot be removed from the property or evicted by the 31st, that's intuitive here. That's not going to happen. Even if I signed the judgment today, that's still not going to happen. And,
Judge,
Mr. Applebaum,
yeah.
sir?
So, Judge, just I get that, and you're probably right on that. Here's the elephant.
I'll take probably right from you, Mr. Applebaum. Go ahead, sir.
So the elephant in the room is that what if the CDC order gets extended again, and then again, and then again? Look, I wouldn't have a problem with if the court said, I'm entering a judgment, you have until 31st and get out. But the problem is that if the court rules that the CDC order applies and that it gets extended again till, let's say, February 28th or whatever, then we're back here again and again and again. So that's why I think that's the issue, is what if it keeps getting extended?
I've taken all those factors into consideration, and my inclination, and I don't avoid issues. I'm like that catcher that's on bent knee and with heavy glove. I'll take the fastest one you can throw. Here, I'm going to take that motion under advisement, and I'll allow the case to proceed, having taken that motion under advisement. If the CDC order gets extended then I'll revisit this issue to the extent that this case is not fully resolved, which it will not be, given the time frame that we're living in right now. So the next order of business on this is then to set a hearing wherein the parties can present their issues before the court, and then the court make a decision as to whether or not judgment should enter. And after judgment enters, then a date will be set whereupon a writ could issue to the extent that judgment is entered in this matter. So the motion for application of the CDC order of stay is taken under advisement, and the court allows the case to proceed to court. So the next, what's a good date to be heard on the issues in this matter? How soon on this school?
What date would you be looking at, Your Honor?
Unless I do it in the afternoon, it would have to be at this point the last week of January. And I've got some restrictions on afternoon because the court is working administratively through some issues about what they're getting ready to put in the afternoon. And I don't have clarity on that. So the thing that I'm working with is daytime. So that week of the 25th of January is about when I would have to deal with this from a hearing standpoint. Obviously, Mr. Applebaum, I suppose there are strategic ways that he could file something regarding some redisposition or something along those lines. I'll hear anything that the parties want me to hear. But if I'm setting the date for hearing, I'm into the week of the 25th of January.
I mean, I could do Ms. Cooper's available the 27th.
That would work, Your Honor.
All right. So I'll set the matter over for January the 27th. And I will address this matter as a trial matter on that date. And so I'm going to set it for 10:30 a.m. so that we can get to any testimony that might be offered at that time.
Judge, just not to create the court any more headaches, but I would like an escrow order considering it's been several months.
Your Honor, I don't think it's appropriate in a termination of tenancy case.
It's under the court rule, the escrow court rule, 4.201 does not distinguish between termination of tenancy and non-payment of rent. It's if the court adjourns more than 7 days, the court may institute an escrow order. In this case, the defendants are residing there. They've been residing there for a long time. The escrow order cannot be retroactive. So I don't see what the prejudice is on the part of the defendants. They don't have to escrow with the court. They can escrow it with Ms. Cooper or whoever. But just, I think an escrow order is appropriate.
Your Honor, we don't do escrow at our firm, and I don't think it is appropriate in termination of tenancy case. My clients were paying rent until the landlord stopped accepting rent.
All right. Well, the nature of escrow means that it's neither the defendant's money nor the landowner's money, and to the extent that the defendants are residing in the property, and the court's orders allow a continuation of the same, it would seem appropriate to set some type of escrow order in place, and that would deal with the month of January. And it would be prorated at this point, and then it would pick up in the month of February to the extent the parties continue to reside at the property at that time. So under the circumstance, I will allow for the escrowing of funds in this matter. What is the monthly rate?
It's $755.
All right, so $755. That amount will be prorated, and an amount that is consistent with 23 days would have to be placed in escrow within the next 7 days.
So, Your Honor, is the court still closed to the public?
Yes, to a certain extent. I I would suggest that, given that Ms. Cooper's office does not handle escrow matters, that the funds be escrowed with Mr. Applebaum's office. And again, that money would still be controlled by both sides. And if it's controlled with his office, whatever the court orders, that's what Mr. Applebaum's going to have to do anyway. Doesn't matter whether it's Ms. Cooper's office or Mr. Applebaum's office. It's money under the court's control. Sending it here to court during this season, to be kind, is somewhat disastrous. There's just too much going on, and I say that with a great deal of sadness, but it's very, very difficult right now. Somebody made an escrow. I had a case the other day. Somebody made an escrow deposit a couple of months ago, a month and a half ago, and to use computer language, it has not populated yet. So there's no way that I'm going to order that an escrow payment be directed to the court. And I can trust the lawyers because, well, you guys, for obvious reasons, I can trust the lawyers. So, I'll make Mr. Applebaum's office the escrow agent on the funds. The parties will need to make sure that they have appropriate information where the funds can be sent to Mr. Applebaum's office, and his office will be the escrow agent in regard to this matter. No funds are to be dispersed without an order of this court. Come the month of February, on the first or within 7 days of the 1st of February, rent would have to be deposited into the escrow at Mr. Applebaum's office. All right, that is the order of the court, and that will resolve the case for now with the hearing date set as previously indicated.
All right. Thank you, Judge.
Thank
Your Honor.
That was at 10:30, Judge?
That's at 10:30 on the 27th of January.
Oh, okay.
Just one moment. Mr. Seeker. Make sure we keep up.
Okay.
Mr. Abbott, I see that you're there as well. I'm coming to you on 3 matters that I still have with you. And then I'm back on record in the suffix 2258. That's URTH versus Eric Hovath regarding the property on Longworth. And your appearance at this time, Mr. Sequel, I know that you did your appearance. Counsel, your appearance for Mr. Hovath.
Yes, Lucia DeSico, P72856.
All right.
Can you say your P again, please?
Yes, P72856.
Thank you.
Thank you. For defendant at this time. Ms. Mulvey, did you talk to Mr. Holbeck?
Good morning, Your Honor. Angela Malvig, P83921. I did speak with the defendant. However, our office will not be representing him on this matter.
He was here. It looks like he disappeared. Must have lost contact or something.
He was having tech issues while we were in the breakout room, so he might be trying to get back on here.
All right, Mr. Seco, we'll come right back to your matter, ma'am. So I'm going to give him a moment to try and get back in. I did see that he had returned. Not here at this moment. Okay, so I'm back on the record. Let me go to 19361655. That is land contract Detroit versus James Green regarding property at 5051 Nottingham. The court calls 7402. Leland House versus Jamie Gatlin and other occupants of property at 400 Bagley, number 2154. The court also calls the subject 7406, that's Centurion Capital versus Yolanda Jones and other occupants of property at 15827 Biltmore. All right, Mr. Abbott, are you there, sir? Your appearance at this time.
Your Honor. Good morning. My name is James Abbott, P26085. I represent Land Contract Detroit, Leland House Apartments, and Centurion Capital.
All right, thank you, counsel. And Ms. Willingham indicated that she was representing Mr. James Green, and I see Ms. Willingham. Ma'am, you may at this time, please.
Good morning, Your Honor. Again, for the record, Jamesia Willingham with Michigan Legal Services, P83986, on behalf of Ms. Patricia Green.
All right, and my understanding is that you've had difficulty making any contact with Mr. Green. He's not responded to your calls. Is that correct, Madam Counsel?
That's correct, Your Honor. I was in contact with Ms. Patricia Green, and she has not contacted me, and I've made several attempts to contact her, and I have gotten no response back. It's been a couple of weeks since I've contacted her, and at this time, I actually would like to withdraw from representation due to her unresponsiveness. And if your court so wishes, I can send an order for that.
Well, I'll grant, under the circumstance, your permission to withdraw from this matter, ma'am, and please submit an order and I'll sign it accordingly. Mr. Abbott, in this regard, sir, your pleasure, sir.
I believe this is an adjourned writ hearing for a judgment we took back in September of 2019. There's been no rent for over a year. I think it's high time that the plaintiff get his property back. So I would ask that the writ, once filed, now be signed and executed.
All right. And the court has received the writ that has been filed in this matter. I will grant the writ application under these circumstances and allow for its execution. The writ may be executed, the court assigned it the date, the writ may be executed on or after the 22nd of January 2021.
Thank you.
So, I see that you're back, Mr. Holbach. I'll be right with you, sir. Just kind of mute yourself for just a moment, Ms. Holbach. Too much sound. Be right with you. All right, Mr. Abbott, on regard to the 7402, do I have Jamie Gatlin on this Zoom or any person living at the property on Bagley Street? All right, it does not appear that it's the same person as appeared. It does appear that this is the first hearing regarding this matter. Also, regarding the subject 7406, do I have Yolanda Jones? Yolanda Jones on that. And actually, it looks like here on both of these matters, there was a hearing on the 4th of November. It looks like the matters were adjourned to the 24th of November. The court was closed by the 24th of November due to the pandemic. And so this would appear to be the second hearing regarding both of these matters. So,
those children aren't mine, Your Honor.
I'm sorry,
good morning. Yes.
There's a lot of kids in the background, Judge. It's kind of difficult to hear.
Yeah, I got you. 1 second, man. All right, Mr. Abbott.
Thank you. I'd like to submit default judgments for non-payment of rent on both of those two cases, both 406 and 402.
All right, the court will enter the defaults of the defendants with respect to both matters, and the court will sign a judgment with regard to both matters upon presentment to the court. And I await your orders in these matters, Mr. Abbott.
Thank you very much.
Right. It appears that all of your other matters have been resolved. There were several wherein there have been an agreement on EDP and various orders have been submitted for conditional dismissals, and the court previously called those. The attorneys on the other side spoke in those regards, and I've signed those orders, sir.
Thank you very much.
Thank you.
think that concludes my docket at 4:32.
Yes, sir. All right, good day to you, sir.
Good day to you. Have a good weekend.
You too, sir.
Bye.
All right, so I see that Mr. Hobart is back. And sir, I did have to mute you because there was so much noise in the background. And are you able to unmute yourself now, Mr. Hobart, to go back on the record in this matter? Yeah, I can't hear you, so you gotta unmute yourself. Push something that will allow you to talk to me. I'm not hearing you because you're on mute. So unmute yourself if you will. Mr. Hobart, you probably do this, sir. You probably need to hang up and call back in because I can't hear you and you're on mute. So you need to unmute yourself or hang up and call back in. I'll wait for you.
Your Honor, if I may, this is Angela, P83921 again. Mr. Horvath was having issues. His phone doesn't seem to have the same buttons that most phones have. I don't know what the deal is. Is there any way you could unmute him as the host?
Why would you put me on the spot like that? I don't think I can. I don't think I can. Maybe I'm not as sophisticated. So I'm looking for a way to do that as we speak.
He just needs to hit the button he hit to mute himself.
No, that's I muted him, and that's one of the challenges here. Is
Your Honor, I think if you go into the participants list, I think you can request to unmute from there.
All right, I have some smart people here. I'm telling you, this is.
It's a team effort, Your Honor.
Yeah, I know. If it doesn't work, I get to blame you. Though. It's your fault.
That's fine too. I'll take that.
It's not giving me an option.
Who is he talking to?
I don't get that. I've always wondered about that. I invested in how all of this works, but it seems to me that being able to unmute should be a simple thing. And I'm not finding an option to do that.
Can an attorney call him on the phone?
Well, I think he can hear me. I suggested that he hang up and call back in, and he is constantly talking. That's not helping us. So I do get a drop down menu, Ms. Enright, but that drop down menu does not have an option.
You have the list of participants open on like the side of your screen.
Yes.
And it doesn't have one if you're next to his name.
Yeah.
Hello? Your Honor, I beg your pardon. Can you hear me?
I can hear you now, sir. I can hear you now.
Okay, I was on mute, okay? Somehow it popped up. Now, if you can tell me how to mute me again, my request is, can I talk to the opposing lawyer? Can we go to that breakout room? Is there any kind of way we can do that?
All right, Mr. Seco, are you willing to have a private occasion to kind of talk with Mr. Hobart? He wants to talk.
Yes, Your Honor, I can speak with him. That would be fine.
All right. So I'm gonna send you. Okay. I'm gonna send you to a breakout room to talk with Mr. Seco, and I'll wait for you guys to come back. Okay.
Thank you, sir.
You're gonna see the button where I'm going to put you somewhere in just a moment.
Okay, though.
I'm going to go ahead and put you in number 1. I'm also going to send you there, Mr. Seco, to number 1. And
Thank you, sir.
so, Ms. Enright, don't go back to 1.
Okay, I'm gonna hit the join button right now.
Yes, sir. Go right ahead.
Thank you, sir.
So did you get him to unmute or did he figure it out on his own, Your Honor?
He did it on his own.
Oh, okay. There is a way. I just I have to
There's
remember.
got to be, and I'm sure it's something very simple. And I got the drop down menu, of course, and I see where where he was muted. I got another drop down menu by clicking on, but it doesn't give me. It did not give me the option to unmute it.
Judge, can I have 1 minute?
No.
Thank
Sure.
you.
Go right ahead, ma'am.
Okay, I'm back. They're back too.
Why do I still have you on my phone?
All right. Did you go into the breakout room?
Yes, we did, Your Honor. We're ready to proceed on the record.
All right. Very well. You may update me at this time, Mr. Seco, please.
Yes, thank you. Your Honor, this case was actually handled on February 14th of 2020. The defendant signed a consent judgment where they agreed to move out by April 30th of 2020. My client offered to give the defendant additional time to move out. That was the original agreement. The writ for eviction was then filed in October. Obviously, we had a moratorium on evictions. And at this time, we are asking to retake possession of the property. It is our understanding that the defendant has had ample time to move, signed the consent agreement, understanding what was happening. And at this point, my client would like to retake possession of the property.
Thank you. And Mr. Holub, I do see the history of this file, and I do see that on the 4th of February 2020, that there was a consent agreement in this matter, and that agreement was placed on the record that allowed for the 30th of April as the move-out date, and it waived the 56-day rule. So subsequent to that time, of course, we were in a pandemic, and so the thing that's pending before this court is the application for a writ. There is an agreement to move out that gave all the balance of February, March, and all of April to move out of the property. So what gives in regard to this, sir, is basically a motion asking the court to sign the writ. Go right ahead, sir.
Well, this is obviously the elephant in the room is that the pandemic, and God bless our governor who said non-essential jobs and businesses cannot operate. And the U-Haul and these other corporations that do that They were not in there. I don't have a Honda Civic. There's 2 seats and a steering wheel. That's it. And I've been there for 24 years and raised 2 boys. There's a lot of stuff there, and obviously when you hang on to stuff, you got junk. But this pandemic has put a spin on everything. And I have tried to contact her multiple times that if you just be patient, we'll all 3 go through a walkthrough. I'll give you the keys. She's an officer of the court, so you can see there's no damage. This house is yours. I was there for 24 years. I mean, it is what it is. It took time to find another house. It took, in fact, and counsel that I just got off with told me to tell you that this cat broke into the house while I was living there at work. He, in fact, went at night, cut a hole in my fence, went to the back door with a 3-foot pry bar with his little grimy little partner and broke into my home while I was living there. I'm like, I come home from work, he's sitting on the porch like he's the cat's meow. No, he broke the law. And I told him, you got a sign or a deed, a registered deed. He said, no. It's like, when you go and get forfeiture properties, even at the Wayne County sale, they tell you you cannot go on the property without a registered deed. This guy did not have a registered deed and broke into my property while I was living there in the middle of the night. All right. Secondly, he did not have a notice of eviction. Okay. I know I signed that. I had every intention to get out. I lost the house. I have a lot of Christmases there, a lot of Thanksgivings there. There's a lot of memories. 24 years of raising 2 kids. But the law is still the law. He broke the law. He broke the law. Now, I would sign that paper in good faith, that, listen, I'll give you the property. I don't have a problem with it. But this pandemic, and we know how devastating this has been, not only for me, but for everyone in the United States and around the world. It's crazy. I'm asking for 60 days. That's it, Your Honor. And we'll still do the same thing that I proposed. I'll give him the keys. She's an officer of the court. Me, her, and him can walk through the property in 60 days. Bam, there you go. This is your house. That's what I'm asking, 60 days. And I bought a truck, Your Honor. Check this out. I bought my own truck. I can't wait on U-Haul and Ryder and all the rest of these cats, Penske. I bought a truck. And me and my 2 boys, we've got most of the stuff boxed up. All right. We haven't been stagnant here. We've been diligent. Everything's boxed up. We just got, well, not everything. I mean, I'm not going to lie. I'm not going to start lying. But 90% is pretty much boxed up. And, you know, well, it's not even 90%. Let me quit lying. But we're ready to rock here. I mean, we got progress going on. You got to remember, there's 24 years. 24 years I was there. I lost this through tax foreclosure. And I begged them for help. They say, no. You got to go. I'm like, come on, man. I've got a record of 24 years of paying my taxes. They say no. Well, okay. I lost my house, man. It is what it is. The house ain't being destroyed. It's in great shape. I'm going to leave it to them in great shape, and I'm offering them the same deal. You, me, and your client will walk through this house together, and I'll drop the keys right in your hand. I'm asking this court for 60 days. After that, you can call the wolves on me. I don't care. 60 days is all I'm asking for. Let me get my stuff out of there. It's a nice house. It's a nice house. It really is. It's a nice house. I lost.
So you prefer the wolves, not the elephants, huh? You don't have to answer. All right. So let me ask you this. Let me ask you this, sir.
Correct, sir.
When was there a break-in? When did this person come into your property? How long ago was it?
He broke in about a month and a half after I went downtown at the Wayne County room 300 and begged for help. And about a month and a half after, he did not. And the law says you have to show me a deed, a registered deed. He didn't have a registered deed.
Right. You told me that already. What I'm trying to get out is, did that happen after this came to court, or that was before this came to court?
Prior.
Okay. Did you call the police during that time, or?
Yes, I did. And they showed up. And he had my stuff, started having my stuff lined up at the door. Him and his little partner in crime had started lining up my stuff at the door. I raised 10 speed bikes. They started lining up my stuff at the door to steal it. And the two Detroit cops.
Yeah, it would seem to me that would be illegal. That's not a part of this case because that happened before this case came to the court.
That is correct.
I would really be concerned if that happened while this case was pending before the court, because only under any circumstance it would only be the bailiff of a court pursuant to a court order that would be allowed to actually have you to move your stuff out. Mr. Seco,
Your Honor, if I may interject, if you don't mind, please. She is well abreast that this happened. She is well abreast of this incident happening.
All right, thank you, sir. All right, Mr. Seco, I know I've heard information regarding the incident that occurred. That, of course, seemed to be before the filing of this case. So we're really on the issue. Mr. Holbeth obviously has been there a long time since owning the property, and then subsequent to the plaintiff getting a deed with respect to the property. He's asking for 60 days to finish the move-out process. That's what his request is in this matter. I believe that at this point, the plaintiff would, under these circumstances, be entitled to a writ. The issue here is he needs additional time to move his stuff. And just your thoughts in that regard, ma'am.
Your Honor, my client did purchase this property in 2009. The deed that I have here is from October of 2019. Excuse me, Your Honor, 2019. The judgment was entered in February of 2020. I understand everything that the defendant has said. However, I'm asking for that writ to be signed today. He has known since February 2nd of 2020 that he would need to vacate the property, originally by April 30th of 2020. So from that point to now, I think he's had ample time to pack up the home and find an alternate place to live.
All right. As I suggested in this matter, I believe that the plaintiff is entitled to get possession and recovery of the property. So I will sign a writ today, but I won't let it be executed until on or after the 4th of February. What that does is you've had a year, sir. This judgment was entered February 4th of 2020. I'll give you until February the 4th of 2021. On or after the 4th of February, either on that date or any date after that, this writ can be executed. I'm signing it today, but I'm delaying the execution until the 4th of February. You got to be out of there, otherwise it can be executed. The processing can start now. The bailiff will have to stand down until the 4th. On the 4th, he can come and move your stuff out of the property. That's going to be my order. I do wish both sides well, and you'll receive a copy of this order momentarily. Okay?
Can I ask the court?
Thank
for
you, Your
February the 20th?
No. That 4th is what I'm giving you because that gives you a whole year since this judgment's been entered. That's been a long time. I understand that there's been a pandemic. That's a significant issue here, and nobody.
Yes, Your Honor. And everything's been closed down.
Yeah, that's a significant concern, and that's the only reason that it's extended the way that it is. So I'll give you until the 4th, and you gotta get your stuff out of there. Otherwise, it's gonna be a legal an eviction that is legal in nature, and I don't want that to happen. I wish you well. Thank you and good day. That's the end of the hearing on
Thank
this.
you.
Thank you,
Thank you,
Your
Your
Honor.
Honor.
For that escrow order, that money was to be paid directly to the plaintiff.
Yes.
Attorney. Okay.
Well, what happened? The place just blew up.
Sorry?
I said, what happened?
What are you talking about? What happened, Debbie?
No, everything was running so smooth. Then it just kind of went haywire.
Well, we're still smooth. Spice of life.
Your Honor, I'm going to email you a document about how to mute and unmute people, so you can do that in the future. So you are empowered to do that in the future.
You'd have to tell everybody. No, thank you.
Well,
very
I mean,
much.
I can't stop the live streaming. You can stop it and we can have this conversation. But
Yeah. See,